If you are a U.S. citizen, a green card holder, or a family member waiting for a visa approval, please take a moment to breathe with me. Go ahead, just one breath. I know the headlines out there right now can feel loud. I know that every new notification on your phone can make your heart skip a beat. And I know that when it comes to your family, to your future, to the people you love, you cannot afford to get this wrong. My name is, and my goal today is not to give you more anxiety. My goal is to give you the quiet truth. We are going to separate the rumors from the reality. We are going to look at what was actually released, what it actually means, and most importantly, what it means for you. So please stay with me, pour yourself a cup of tea, and let's talk. Now, before we look at the documents, I want to say something important. I am your guide today, not your lawyer. Everything I am sharing with you is for your peace of mind and your education. I am going to explain it simply, the way I would explain it to my own grandmother, my own father, my own family sitting at the kitchen table. If your case has specific details, please always confirm with a licensed immigration attorney. But what I can do is give you the clearest possible map of what this bulletin says, and that matters. That matters a lot. All right, let's get into it. The March 2026 Visa Bulletin has been officially released. The U.S. Department of State published it, and USCIS, that is U.S. Citizenship and Immigration Services, has confirmed which chart applies this month. Now, I know those words can feel like a foreign language, so let me explain this slowly. Every single month, the government releases what is called a Visa Bulletin. Think of it like a schedule, a train schedule for immigration. It tells you, based on when you filed your petition, based on your country of birth, based on your visa category, are you close to the front of the line, or do you have more waiting to do? That is it. That is all the Visa Bulletin is, a monthly schedule update. The headlines say, Act Now. And for some of you, that is absolutely true. For others, this is simply good news to understand. Let me walk you through both. Here is what is new this month. And I want you to listen carefully because for many families, this is significant. The biggest development in the March 2026 Visa Bulletin is in the employment-based category, specifically EB2. Now, EB2 is for workers with advanced degrees or exceptional ability. And this month, for almost every country in the world except China and India, the EB2 filing date has become current. That word, current, means you can file now. There is no wait. The door is open. For India, the EB2 category moved forward by nearly 11 months. That is not a small step. That is a significant leap. If you are from India and you have been waiting in the EB2 line, this month is worth paying close attention to. For China, the EB2 dates did not move this month. The wait continues. But for the rest of the world, the line has moved considerably. Let me take a breath here and repeat that in plain language. In the vast majority of cases, if you are an employment-based applicant from any country outside of India and China, your EB2 filing date is now current. That means you may be able to file your adjustment of status application, your green card application, right now, this month. Now, there is something else I want to explain carefully, because this is where a lot of confusion comes in. USCIS this month is using what is called the Dates for Filing chart. They call it Chart B. There are two charts in the Visa Bulletin every month, a Final Action Dates chart and a Dates for Filing chart. The Final Action chart tells you when your green card can actually be approved. The Dates for Filing chart tells you when you can submit your application. This month, USCIS said, use Chart B, use the Dates for Filing chart. What does that mean for you in real life? It means that even if your green card cannot be approved yet, even if the final approval date has not arrived, you may still be able to file your paperwork now, and filing now matters. Because the moment you file, you can also apply for a work permit and travel authorization while you wait. That can change your life while you are in the process. Filing is not the same as finishing, but filing protects your place in line. Now, let me speak for a moment to those of you who are not in an employment based category, those of you waiting on family petitions. If you are a U.S. citizen who has filed for a spouse, a child, or a sibling, I hear you. The family based categories move more slowly. They always have, and I know that slowness can feel unbearable when the person you are waiting for is someone you love. Here is the truth. The law is on your side. The petition you filed, that record, that document, it is preserved. The government does not forget it. The system does not erase it. The weight is real, but the foundation is solid. For those of you over 60 who are waiting for family members to join you, I want to speak to you specifically. You have been patient. You have been strong. The strength of this system is that it is built on documentation and record. Your petition has a date. That date matters, and time, as slow as it moves, is a factor that works in your favor. The law is on your side. Let me also address something I know many of you are thinking. Why haven't I heard anything from USCIS? Why is my mailbox empty? I want you to hear this clearly. Silence from USCIS is not bad news. In the vast majority of cases, no news is simply processing news. The government is processing thousands, sometimes millions, of applications at once. The system is large, it moves slowly. Think of it like a big ship at sea. A big ship cannot make a sharp turn. It moves with intention, with structure, with time. A delay is not a denial. A quiet mailbox is not a closed door. If your application is pending, if you have not received any request for additional information, if you have no notices of action that concern you, that silence may simply mean your application is in the queue being processed. That is normal. That is expected. That is the system working the way it is designed to work. Now, let me speak about something that I think is very important and that the headlines sometimes get wrong. There is a difference between a policy pause and a law change. These are very different things. When a court issues a ruling, when a new bulletin adjusts a date, when an agency releases new guidance, these are not necessarily changes to the law. They are often adjustments within the law. The law itself is passed by Congress. Courts and agencies operate within that law. They can shift how the law is applied in a given month, in a given case, in a given circumstance. But the underlying foundation, the Immigration and Nationality Act, the rights it protects, the processes it guarantees, that foundation does not change with a single headline. So when you hear urgent or confirmed change, ask yourself, is this a change to the law or is this a change in the schedule? Most of the time, it is the schedule. Most of the time, it is the monthly train schedule getting updated. That is manageable. That is workable. That does not shake your foundation. I also want to reassure those of you who already have your green card, those of you who are lawful permanent residents. The March 2026 Visa Bulletin does not affect you. Your green card is your green card. The date adjustments in the bulletin apply to people who are still waiting in line, still waiting to file, still waiting for their applications to be processed. You can rest easy because your status is already established. Your record is already in place. And for those of you who are naturalized U.S. citizens, you are home. Bulletins like this do not threaten what you have built. You are a citizen. Your foundation is not just solid, it is concrete. Let me now give you the key facts one more time clearly and simply so you can write them down or share them with your family. Number one, the March 2026 Visa Bulletin has been officially released by the U.S. Department of State. Number two, USCIS is using the dates for filing Chart B, for employment-based applications in March. This is an important detail. It means more people can file this month than in previous months. Number three, for EB2 applicants from most countries, every country except India and China, the filing date is now current. If you are in this category, talk to your attorney this week. Number four, for EB2 applicants from India, there has been a meaningful forward movement of nearly 11 months. This is the biggest advancement for this category in recent memory. Number five, For family-based applicants, continue to monitor the bulletin monthly. The dates move more slowly in family categories, but the law protects your place. Number 6, for green card holders and naturalized citizens, this bulletin does not change your status. You can rest easy. I want to close with something personal. I know you are counting the days. I know the empty mailbox feels heavy. I know that when you are waiting for a visa, for a green card, for a family member to arrive, time does not feel neutral. Time feels like it is working against you. And the headlines, the urgent warnings, the act now messages, they can make everything feel even more fragile. But I want you to know something. You are not alone. Millions of families are in this process alongside you. And the system, for all its slowness, for all its bureaucracy, is structured. It is documented. It is not built on sudden whims. It is built on law. It is built on process. It is built on the understanding that your application matters. The law is on your side. The structure remains, and every month that bulletin gets updated, which means the line is moving. Slowly, yes, but moving. So here is where we stand today, clearly and without hype. The March 2026 Visa Bulletin was released. It contains significant good news, especially for employment-based applicants in the EB2 category. USCIS is honoring the dates for filing chart, which opens new filing opportunities this month. If you are in an EB2 category from any country outside of India and China, speak with your immigration attorney immediately. If you are from India in EB2, your date has advanced significantly. Also worth a conversation with your attorney, family-based applicants should continue to monitor the bulletin and maintain their documentation. And those who already have green cards or citizenship, your foundation is untouched. That is the quiet truth. No panic, just facts, just a clear map of where we are. If this brought you a bit of peace today, let me know in the comments. I read them all. I want to hear from you. Tell me your category, tell me your country, tell me how long you have been waiting, and I will do my best to point you toward the information you need. Stay informed, stay calm, and I will see you in the next update.